And now we'll take some time. Everybody can 2 or 3 minutes responses if you have any.
I guess I'll start, and we'll just go, can we just go back to the same order? Just 3 quick points that I would make. One is Elizabeth started with the California Court of Appeal decision saying that the duty to warn is ongoing, and I agree with that, subject to the state statutes I mentioned. But I think the key question is not whether the duty exists, but how it is discharged. And what I would, what sticks in my mind, the phrase I like to use, is the difference between the capital W and the lowercase w. There is a lowercase state law duty to warn that, if I were to generalize it, is the duty to act reasonably under the circumstances to give physicians the information they need. There is a capital W that is the warning label section of a label of an FDA drug. Those are not the same thing. And the point I was trying to make is, I don't think the existence of the CBE procedure, which also speaks in may terms, necessarily means that the failure to utilize CBE makes a case something like a directed verdict case. I think if you took a hypothetical where 1 million people took a product and there was one adverse report of someone having a skin reaction, that would not necessarily mean that the pharmaceutical company and the FDA made a mistake, acted unreasonably in not putting that in the warning section of the label. Those are just different questions. And if you directed a verdict in that case, or I think even if a trial court instructed the jury that the pharmaceutical company had a duty to utilize CBE to add that information to the warning label, that would be error. And the best case, I think, that elucidates a lot of that is a case from New Jersey called Feldman, that's from the New Jersey Supreme Court, that goes through the argument I'm making and just says, look, these are different questions, and you can't take away from the jury the ability to decide whether the company acted reasonably by saying the duty included the duty to make a label change. Second point I wanted to make is just a little quibble about the nature of the post-approval safety review process. I don't think that the safety of a drug following approval is something that a pharmaceutical company can keep in a black box. It's out there in the world. It's in patients. There are adverse events. There are these published case reports. There are clinical studies. If the company wants to have a further use of the product, they're going to have to make a supplemental application and put that before the FDA. So there is just a lot of information that's out there, and it's not as though these risks can be hidden from the world. And so I think it's important to bear that in mind. And the FDA does have, especially after some amendments to the legislation in 2007, substantial authority to bring enforcement actions, to seize a drug, to declare a drug misbranded, to withdraw its approval of the labeling, and so those are things that the FDA can do. The final point I wanted to make is not on our topic, but on this topic, and I just wanted to end by echoing my own personal view of skepticism toward the slides about the drugs that have been withdrawn in the last 10 years and what we can glean from that. I would be skeptical of a view that because a drug got withdrawn due to adverse events, it means that adverse events establish causation. I mean, oftentimes the drug company, I have some litigation experience with some of those cases, and the company's decision to withdraw the drug, for example, might be because they understand that there is an incremental risk of their drug versus another drug, and there might be other drugs out there that have the same or a similar clinical benefit, and so out of an abundance of caution, the right thing to do under those circumstances is to pull the drug for now, at least, until more data can be gathered, more studies can be conducted. And that would not, I don't think, in any court in this country be evidence that the drug can cause or did cause any of those specific conditions.
I certainly do agree that the question of whether or not a post-approval duty to warn has been discharged in a given case is a question of fact for the trier of fact, and it would be highly unusual, I think, to see that decided either on summary judgment or directed verdict, because it does have to be weighed and considered in the context of all the evidence. I think the victory of Wyeth versus Levine was that it stopped the doctrine of preemption from being misused to create a complete defense that cut off any proof with respect to whether or not that duty had been discharged in some sort of safe haven of marketing approval. And I think that's the import there. But I don't think anyone is suggesting that there is now a duty to warn that can be decided as a matter of law against manufacturers. With respect to Daubert, this also implicates Daubert. I would suggest that it's well to be skeptical of the Daubert process, because it's part of the scientific method to be skeptical, and the success of Daubert ought not to be weighed in the number of expert opinions that have been excluded by invoking that decision. After all, at the time Galileo espoused the heliocentric thesis, the Inquisition would have been correct to have rejected it applying Daubert criteria. The germ theory of disease would not have fared any better, but we now accept both. And so there are various ways of proving or establishing causation. Usually multiple ways will be applied. And I think that to equate Daubert with permission or a mandate to select as among competing experts, or to select the more orthodox, comfortable, or familiar hypothesis as against the unexpected or upsetting hypothesis, absolutely perverts the scientific method and is withholding crucial information from fact finders. We all make decisions based on common sense. We use creativity. We challenge ourselves. That's what scientists do too, and to suggest that juries can't do that and they must be protected from that scientific process and subjected to the pre-gurgitated or regurgitated opinions of one side or the other, I think is a misuse of Daubert. I think if we went back to the original intent of Daubert and simply applied the Daubert decision, we would see fewer disqualifications and more legitimate evidence that would be available to triers of fact.
I just want to say, first of all, that some of those statistics about witnesses being thrown out under Daubert include the defense experts that I got thrown out in some cases. So it's not always a one-way street. But my general experience with this is, and let me just back up by saying, my first trial when I was 2 years out of school was the Bendectin Common Issues trial. I was third chair with Frank Woodside and Vince Stamp. I was defense counsel, and it was my first time in court, and the issue was, does Bendectin cause birth defects, and if so, which ones? And we had 2,000 cases consolidated in this MDL proceeding, and we had 27 epidemiology studies that supported, for the most part, the safety of Bendectin, and it was being opposed by the plaintiff's evidence in that particular case, which tended more towards animal studies, the chemical structure analysis, in the face of all this epidemiology. That's what makes the reliance on the Daubert opinion all by itself very deceptive, because it's such an unusual fact pattern. But at any rate, after a 6-week trial, and all the evidence came in this trial, this was in 1984, the jury was out about 3.5, 4 hours. They were done by lunch, and we had a defense verdict on all counts. So to the question of should a defense attorney be able to handle the evidence and explain epidemiology and science and causation, yes, that is the job. And we got the same result in a trial. And frankly, yeah, 6-week trial is a long time, but it wasn't as long as it took to go all the way up and down the Supreme Court to win on a motion. So, at some point you have to look at, do we really need to have the judges throwing out all the witnesses? That's what, can't the jury hear it? That's the only question. Can the jury hear it? You can always direct a verdict later if you really think something went that, wrong. But to spend all this time on briefing, and what just drives me crazy in terms of our practice is, as soon as you sit down, you start making a schedule, and then automatically, okay, and when should the Daubert briefing be? And I'll say, wait a minute, we haven't even named our experts yet. Why are we automatically presuming that everybody, or, I always say, if you're going to do it to me, I'm doing it to you. So I always file Daubert motions against the defense experts, and I can usually pick apart their opinions just as much as they can pick apart ours. But why do we assume that you automatically have Daubert briefing? And I know when I first started practice in our district, you were very much discouraged from filing summary judgment motions. And then, of course, the Supreme Court had their decisions that changed that philosophy. But you really find that this automatic, you're entitled to summary judgment, you're entitled to Daubert, it's, to me, really jumping ahead, and it's a huge expense. And there's other things you could do. You could brief and not necessarily have to bring witnesses in. You can have the Daubert challenge simultaneously with the trial. You can put the witness on, the witness can be qualified, the court can hear it, the court can decide to exclude evidence or have the jury out of the hearing and proffer the evidence. There's things you can do, and it's just important to consider because the expense of basically trying your case twice is very prohibitive in these complicated scientific matters.
Kate?
Well, I think Daubert itself answered a lot of the comments that have just been made. And Daubert says it has to be a pretrial resolution, and it should be. It's to save the parties the expense of trial. If the question was, can a jury handle it, Daubert doesn't need to exist. And the point of the charts is to show the real value that Daubert has brought to these cases. If we're right, and they're right, 50% of the time, then too much junk science has been reaching juries. And this is something that the Supreme Court wants stopped. It's what a great tool they have given us to stop it. Half of the time, the challenges have been successful. That's a remarkable statistic. And yes, might there be evidence that develops later showing that a drug, in fact, causes an event? That's possible. And Daubert spoke to that too, and the Seventh Circuit spoke to that. Law lags science. That's the evidentiary standard that we're dealing with right now.
Okay, we've got some time for a few questions. So if anybody has any.
Counsel, based on your experience nationwide and massaging Daubert, is not Daubert and Kelly Fry a distinct difference?
I haven't directly done any Kelly Fry hearings. I do think they're pretty similar. Maybe Elizabeth, have you done some Kelly Fry?
In California, we have Kelly Fry in state court, and we have Daubert in federal court. And I would say that if you properly used and skeptically used both tools, you should end up qualifying or not qualifying the same witnesses. In New York, I think just as a matter of convention and practice, they probably would admit more witnesses just in deference to the jury. So I think it's more the philosophy of the court rather than what a particular case law standard is compelling.
I guess I would add that there are examples in significant litigation where Fry courts and Daubert courts have come out in very different ways, looking at the exact same evidence. Most recently, that I can think of, the Accutane litigation, same evidence, same experts, different results. I think driven by the standard myself, the Fry standard gets incorporated into Daubert, but under a lot of courts looking at Fry, they don't consider necessarily, I don't know about every jurisdiction, but they don't consider necessarily why or how something became generally accepted, and Daubert requires a court to take a look at that.
Oh, I also think the irony of all this is that as originally written, Daubert was meant to liberalize the Fry standard and to give courts more leeway to allow cutting-edge expert opinion and scientific theories, and it's worked out the opposite.
Any other questions?
One question, and that is, you talked about the opinion of Levine and what it does and doesn't permit. And the court said in Levine that where the FDA would not have authorized the change, then it would be a different outcome. And I guess my question is, assuming a manufacturer has a post-approval duty to monitor, but there are situations, and it's basically a situation in which the FDA's own rules say you can't change a label without prior approval. That's true, for example, a highlight section or a rent. How should the court deal with that situation where the argument is you should have changed it, but in order to make the change, you need the FDA's approval? How would the court determine whether the condition of Levine is satisfied?
That's a good hypothetical. I actually hadn't thought of that hypothetical before. There would be circumstances, I think, under which the company would be in that quandary, and would probably be at some risk in those circumstances. The opinion just doesn't address those. It also doesn't address the question of how you're supposed to decide this counterfactual question of what would the FDA have done. How do you provide that kind of clear evidence? I think that in a circumstance, and this is some of the cases that you see litigated, in a circumstance in which the FDA has been made aware of a risk, let's say a new study, and has carefully analyzed that and decides to approve a label change in a specific way, implicit in that is the decision not to change it in another way. Because, depending on what proposals were made and what data they were looking at, that is the decision-making process. And so in those circumstances, I think you would have a very good argument as a manufacturer that that is exactly the kind of clear evidence that Wyeth requires, that the FDA would not have approved CBE, partly for the reasons I was talking about before about the substantive standard for what goes in the different sections of a label. But I agree with you that there are tricky circumstances that haven't been definitively resolved on those questions.
Yeah, and I would say if you've got a clear record that a manufacturer has gone to the FDA with evidence or a new theory or a new study and said, this is bothering us, we think there needs to be an enhanced warning, and this is what we suggest, and the manufacturer basically gets blown off by the FDA, then arguably the duty is discharged, and at that point the manufacturer has to decide, what kind of a dilemma do I want to be in? What we've seen so far factually, though, is that when a manufacturer brings new information to the FDA and wants to propose a label change, there's a negotiation, and it's usually the manufacturer that is negotiating for fewer warnings, less clear language, and it's a back and forth with the agency. And so I don't think we've seen a factual scenario yet, and somebody could correct me if I'm wrong, I'd be interested in seeing it, where a manufacturer comes in later and says, uh-oh, something's happening, we didn't expect it, we don't like it, we want to warn for it, here's a black box that we want to put on our product, and the FDA says, safety schmafety, we've already decided we don't have time for you, go away, you bother us. That's a pretty darn good defense. If you're a manufacturer, I just don't know that it's happened yet.
That's just what I was going to say too. It truly is a hypothetical because that's not what happens. What happens is the FDA will come out with language that's much stronger, and the company will try to soften it. And as we were talking this morning, these drug companies are commercial marketing machines, and they don't want to put anything in the warning that's going to prevent sales. And for instance, in the fen-phen litigation, we actually found a document where they calculated how much money the company would lose if they had a black box warning for Redux. And it was, how $300 million or whatever the number was, but that's how much they don't want to put additional warnings. So it's a hypothetical, but I don't think it's a terribly realistic problem from our view of the world. That depends.
That's the point I was going to make is the point you're making, which is the question of would the FDA have rejected the label change it's not hypothetical at all, because it's not just for the sake of did the manufacturer ask for something stronger, it's for the sake of determining whether the FDA would have approved the label change, because the FDA has the authority either to approve or not approve the label change. So to me, it doesn't matter if the proposal comes from the manufacturer, a third-party petition. If the FDA looks at all the information, looks at all of the data, and makes a decision about what the label should say, you're in the very same circumstance if the FDA, as in the suicidality cases, rejects the inclusion of that risk information in the label than if the manufacturer had been the first party to bring that to the FDA's attention. That's to me what comes out of Wyeth.
I'm sorry, it's time to quit, so I know we've got a few more questions, but help me thank the panelists. Take a break. Thank you.